The court is ready to hear argument this morning in 2290, Aerotek Incorporated versus Boyd from Dallas County and the Fifth Court of Appeals District.
May it please the court, Mr. Coram will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. My name is Bill Coram and I represent Aerotek, a national staffing company in this appeal from the Fifth Court of Appeals. The appeal follows Aerotek's efforts to enforce arbitration agreements between itself and the 4 individual respondents. While there are a number of issues set forth in the parties' briefs, I plan to take what time I have today to try to focus on what I think most important to the issues before the court, and of course to try to address any questions the court may have. What I'd like to do is discuss what I view as the essential issue, the applicable law and standards at issue, including some of the key cases that I think are worth discussing in the time we have, and then talk a little bit about some practical points to consider as the court decides what to do with this case and how it might instruct lower courts to deal with these issues in the future. The essential issue before the court today is, how do we prove or refute electronic signatures in Texas, and what is the appellate standard of review, or the framework, as the Fifth Court of Appeals referred to it, following an evidentiary, or in this case it's been called a TIPS hearing dealing with arbitration agreements. Respondents agree, in fact argued below, that prior to their employment with Aerotek, each of them received, reviewed, electronically signed, and submitted to Aerotek online onboarding paperwork that related to their initial employment with Aerotek. Aerotek contends that the onboarding paperwork contained an arbitration agreement, and the respondents contend that it did not. At the evidentiary hearing on the issue, Aerotek presented documentary evidence and live testimony, including a detailed demonstration of the online onboarding process, establishing that in 2017 alone, Aerotek launched over 465,000 online invitations to candidates for employment. The detailed process and security measures employed to ensure the right person receives and executes the paperwork. We provided evidence that Aerotek had only one such system at all relevant times. We provided evidence that showed date and time-stamped records of each of the respondents' electronic onboarding activities and their electronic signatures as well. We established that it would be essentially impossible for respondents to have completed and submitted the online onboarding paperwork, as they argued they did, without having executed every document required, including the arbitration agreement. In response, the respondents chose to not testify live and provided only affidavits admitting, executing, and submitting the online onboarding paperwork, but denying that the package of paperwork that they reviewed and executed contained an arbitration agreement. Essentially, they said, yeah, that just wasn't there. We deny that was there. In fact, they said they specifically recalled it not being there. So it wasn't that they said, we don't remember. They said, we remember it wasn't. Without explanation, the trial court denied Aerotek's motion, and that decision was affirmed by the Fifth Court of Appeals, finding that Aerotek failed to present evidence establishing the opposite of a vital fact, namely in this case, that vital fact being the respondents' denials that they received and executed the arbitration agreement. The applicable law and standards at issue in this case includes the Uniform Electronic Transactions Act, which deals in large part with electronic signatures and agreements. As the court's aware, it's been adopted by Texas. It's part of the Texas Business and Commerce Code, Section 322. The Fifth Court of Appeals acknowledged that the UETA permits electronic signatures to transact business. This is not contested. The UETA provides that electronic signatures can be established. Let me just read it to you. It says, an electronic record or an electronic signature is attributable to a person if it was the act of the person, and the act of the person may be shown in any manner, including a showing of the efficacy of any security procedure applied to determine the person to which the electronic signature was attributed. I would suggest that Aerotek provided both. We established in a number of manners that these signatures were the signatures of the respondents. We also provided substantial evidence in a detailed online presentation to the trial court by the architect of our system, showing the measures and steps, and they're numerous and they're set out in the briefs, to ensure that the right person receives these applications and that the right person reviews them and executes them and submits them back to us.
So Mr. Corum, if this testimony, sworn testimony from the respondents, is not sufficient to raise a fact issue, what would be?
If their affidavit simply denying that these documents were contained in the package, Your Honor?
Yeah.
Well, a number of things could have theoretically been done, as was done in some of the other cases. For example, in the Ramirez case, let me shift my screen on here so I'm looking more directly at you, where the respondents actually testify and they sit on the stand, and the courts talk about the trial court's ability to review the individuals and assess their credibility and their demeanor from their live testimony. And while in this case, we did agree through a Rule 11 agreement that the affidavit they provided could be provided to the court without objection to its hearsay nature, that didn't allow the judge to assess the individuals and their credibility and their demeanor. So one thing they could do is they could sit on the stand and testify. Another thing they could do is they could seek discovery. They could make some effort. They didn't even ask for discovery, to try to determine how Aerotek's system works, the first time they learned about it was at the TIPS hearing, to try to determine if there could potentially be a problem or some deficiency. Many times when challenging signatures throughout the case law, the courts deal and the parties deal with arguments regarding fraud. They deal with arguments regarding deceit or trickery or misrepresentation. They made no effort to determine if any of those things happened.
Mr. Corum,
Yes, Your Honor.
do you agree with the dissent that the affidavits were filed in bad faith? The dissent cited to Lujan versus Navistar. It sounds like that's what you're arguing, that if someone files a denial, that just is tantamount to bad faith. Do you agree with the dissent's rationale?
Judge, I recognize that the dissent used that terminology a number of times. I haven't myself characterized their affidavits as bad faith. I'm not trying to get inside of their heads and determine what their motives were or whether it would rise to the level of bad faith. I find it odd, at least, that 4 separate individuals who completed online onboarding paperwork, which they admit they did and submitted to Aerotek, have a specific and actual recollection of the absence of a document in a package of online paperwork that they submitted and reviewed independent of one another. They all actually remember that it wasn't there according to them. And then they signed identical affidavits and submitted them. I guess I won't opine whether that is bad faith or not, but it certainly is odd. And I would argue it certainly is insufficient to overcome the conclusively established evidence that Aerotek provided.
What about Mr. Allen, who said that an Aerotek employee affixed his electronic signatures to everything and did not make him aware of the existence of the arbitration agreement?
Sure, Justice Bland. First of all, Mr. Allen also didn't testify before the trial court. He provided an affidavit as well, also executed by the same person, I assume, that had created the others. Now, Mr. Allen is slightly different. Aerotek, as I mentioned, provided evidence that in 2017 alone, we did 465,000 of these. So for many reasons that may be obvious from that number alone, a lot of them are done electronically, partly for the convenience of the contractors. Sometimes we have individuals who are incapable of doing it electronically and remotely, and we do offer them the opportunity to come in and sit down with our people and work through them online, but person to person, sitting in front of a computer. And yes, he denied that the same as the others denied it. And his process was slightly different, but our evidence was the same. And that is, he also went through the same online process, albeit with the help of an individual that contained all of the same information, including the arbitration agreement. So let's talk just a second about the standard of review. The standard that Keller set out, this court set out in Keller 16 years ago, involves an assessment when you're dealing with, and this is uncontested that this is the standard, no one argues this, that the evidence is legally insufficient to support the conclusion. This is the appellate standard review, essentially. The evidence is legally insufficient to support the conclusion if the evidence establishes conclusively the opposite of a vital fact. Here, the vital fact is the respondent's denial that they received and signed the electronic agreements. And the question is, did the evidence that Aerotek presented in particular establish conclusively the opposite of that vital fact? I think one of the things that the court needs to pay particular attention to and could perhaps provide some assistance to the lower courts and the lawyers in the state is, what exactly does that mean? Conclusively established, and how is that going to be applied? And how is it going to be reviewed? If you look at the Fifth Court of Appeals, they say there is no framework upon which they could have reversed this. There are three cases I want to touch upon briefly in the short time I have left. Two are Ramirez and Aerotek. Those two cases are cited by respondents in their briefs. They spend 11 pages on those two cases. Those cases involve a lot of important factual distinctions in terms of what was presented at trial. In Ramirez, for example, the employee actually testified and the employer did not. Quite different than our case. But the most important thing I want to note about those two cases is neither one of them involves situations where there's an allegation that there was an electronic signature. They don't involve signatures. They involve situations where there was implied consent and the employers were arguing that it was a Halliburton style agreement where they had notice that there was an arbitration agreement and that their continued employment constituted an implied consent to an agreement to arbitrate. That is dramatically different than an expressed assent and an electronic signature, an actual signature to an agreement. Now, illustrating the confusion around that, respondents misstate, perhaps misunderstanding Ramirez. In their brief, they say, and this is on page 22, they say the Court of Appeals noted, and this is in Ramirez, that electronic signatures are a gamble. Every employer takes anytime it forgoes employee signature and instead hangs its hat on a fact finder's determination of whether it met Halliburton's notice requirements. That is not what that court said. The court did not say electronic signatures are a gamble. Now, to their credit, they don't start their initial quotation mark until after the words electronic signatures are. What the court was saying is not that electronic signatures are a gamble, but that the Halliburton style agreements where you're dealing with alleged notice and implied consent are a gamble, as opposed to electronic signatures or wet signatures perhaps as well. The one other case I want to mention in the time that I have left is Fry versus Silva. This is a 13th Court of Appeals case. And other than ours, Fry appears to be the only Texas appellate case, the only one we could find, that deals with a challenge to an electronic signature on an arbitration agreement. Fry's came down last July, so it's a fairly new case. It is remarkably similar, I would argue virtually identical to our case. The employer had an electronically signed arbitration agreement. The employee denied receiving or executing the agreement, just like ours. At the evidentiary hearing, the employer presented detailed evidence of its system, how it worked, why it would have been essentially impossible for the electronic paperwork to have been submitted without the employee executing the agreement. Reversing the trial court, the 13th Court of Appeals found that the employer's evidence conclusively established the opposite of the individual employee's testimony that she had not received the executed the agreement. The denials were deemed to be no more than a scintilla of evidence in light of the conclusive evidence presented by the employer. Now, a few things to note. Number one, that trial court was reversed. So the 13th Court of Appeals found that, in fact, despite what the 5th Court of Appeals found in our case, there was, in fact, a framework that allowed for review and for reversal. Number two, there was no finding that the court may have disbelieved the employer's witnesses in that case. And I think this is an important point because our court said that our trial judge might have disbelieved Aerotek's witnesses, might have disbelieved them. I would suggest that's always the case. And if that's the standard of review, we don't have any more appeals because anytime you're dealing with a situation where the employee doesn't even bother to testify, they present nothing. The employer could bring in 5 or 10 or 50 witnesses and present evidence for weeks. And the Court of Appeals could say, they might not have believed them. If that's all that has to happen, we have no electronic agreements and we certainly have no appeals. In the price, yes, sir.
If instead of an electronically signed agreement, the facts of this case involve a paper document for each of the employees that each of which bore their signature, and you had presented those as evidence along with testimony of one of your client's employees saying, yes, I was sitting with this person when they signed it in person, and you had expert handwriting analysis saying, yes, these are these people's signatures. Assume those facts, and yet you still had the counter affidavits from the employees that you have in this case. Would the issues before us right now be any different, or our analysis be any different? And I ask this question because I'm not sure why this is a case about UETA. It's more a case about the standard of review on fact. When does one party's evidence conclusively establish the falsity of another party's evidence, whether it's electronic evidence or physical evidence? Am I wrong about that?
Justice Boyd, I notice I'm out of time. If you will allow me, I'll answer your question.
You may answer.
Okay, thank you, Your Honor. I think it's not necessarily about UETA. I think UETA is only pointed out to establish the, I think, uncontested point that electronic signatures are not really to be treated any differently. And under the facts that you described, Justice Boyd, our Fifth Court of Appeals in our case would say none of that matters, because the trial court may have disbelieved that evidence. They may have disbelieved the person who sat with the witness. They may disbelieve the handwriting expert. They may just disbelieve everything you presented. And all that's needed, according to the Fifth Court of Appeals and our trial court in this case, is a piece of paper from the respondents without testimony that says, yeah, it wasn't me.
Any other questions? Thank you, Mr. Corum.
You're welcome.
We'll hear from the respondents.
May it please the court, Mr. Scott will present argument for respondents.
May it please the court. Aerotek is asking the court to change the law in this case because it doesn't like the result. To do that, it's misrepresented what the Texas court or the Dallas Court of Appeals held, and it's misrepresented what the current law is. Aerotek is asking the court to hold that when a corporation produces an electronic document, those documents are presumptive of a fact. In other words, that the corporation is presumed to be telling the truth. Why would we give a corporate entity such presumptive credence when we don't do that for any other party? It's for the fact finder to determine who's telling the truth and who to believe. And in this case, Aerotek was not believed. I want to address right up front this whole thing about my clients not testifying. That was Mr. Corum's choice because the trial court was short on time and Mr. Corum was here from Kansas City and didn't want to stay. And that was his choice. That's why we had that agreement. That's why the agreement says that their testimony is the same as if they had testified in person. So this notion that somehow their testimony is only an affidavit, that is 100% Mr. Corum's choosing. And that was something that we had all four of my clients there prepared to testify. He determined that he didn't want to examine them. I mean, my testimony from them was going to be along the lines of what they provided in their affidavits. He's the one that chose to forego that opportunity. Now, come back to my argument here. As the party that's seeking to enforce the arbitration agreement, Aerotek has the burden of proving that one existed, and it didn't carry that burden. All it proved was its normal procedures and nothing more. It provided no evidence as to what my clients saw or signed or experienced when they did their computerized onboarding. It just simply outlined its normal procedures. It didn't provide any specifics of what my clients actually did. It just provided evidence of what they should have seen. That's not enough. Justice Boyd, I think your example, that evidence, the example that you've just given is far more evidence than Aerotek came. Aerotek didn't come close to evidence as direct as yours. And I understand where you're going with this is at some point in time, is that appellate court going to say there's just no evidence here, that it's legally insufficient. But the example that you've given, that is far more evidence than Aerotek ever came close to presenting at trial.
So what are you saying, Mr. Scott, what are you saying they should have done that they didn't?
They should have done something that showed what my clients did. They should have been able to explain somehow what my clients actually did and saw. All they did is went through their procedures And then they produce these documents and say they signed it. And the bottom line is the trial judge, Judge Ken Moldberg, who's now on the Dallas Court of Appeals, didn't believe that my clients had signed the arbitration agreements.
Isn't your client in the position of knowing what he or she did?
Yes, and that they are, and that's why they all said we didn't sign it. And that's the other thing I think that it's important to note here is, you know, Mr. Quorum says, well, I find it odd that all these men said that they specifically remember this was not in there. That sort of undermines the whole notion that arbitration is voluntary, because what he's saying is people sign these things and we're going to hold them to them even though they don't know what they're signing. If my clients had told me I don't remember signing that, I would have told them it doesn't matter. If you signed it, it doesn't matter whether you remember it or not. My clients were all adamant. This was not part of the package. We did not sign it. And their testimony on that issue, it's funny because if they had testified, we don't recall, Mr. Quorum would be arguing that's not enough and he'd be correct. But on this particular case, I've got 4 people telling me the same thing. I did not sign this. This was not in the package. And that's the other thing is there's
Mr. Scott, so would the framework, what would that look like? Would that include bringing in IT people or some other forensic testimony? Or I'm not understanding what the framework under your rationale would look like.
And I'll be honest, I don't know that I can tell you because I don't understand their system. I really don't, and I don't think they did a good job of explaining their system to the trial court.
But Mr. Scott, I don't think their system would matter because what you said that was lacking was what your clients did. And if they have to show what your clients did, that's undermining the whole purpose of electronic signatures. I mean, how would they possibly know what your clients did or didn't?
Well, I think
push the button that they saw was pushed or whatever.
When and Your Honor, I use electronic signatures with clients for engagement agreements, and my documentation of that is much more accurate and outlines more than what theirs did. Again, they didn't put on this. There has to be some way if you're going through a system where they can show the movement, show what my clients did, other than just producing what they say is the result. And I don't have I can't tell you that. I'm not an IT person. They also did not bring an IT person. They brought the person who designed the forms. But that is something that is in their bailiwick, and that is something that I think they have to bring to court to explain what my clients, here's you can see him doing this. I mean, there has to be some way to track those things beyond just presenting a document and saying he signed it.
So you need video, Mr. Scott, or yeah, I mean, they did present evidence, right, that the button was pushed. I mean, there's a time and date stamp showing, you know, this particular button was pushed. And so I think I'm just trying to figure out, do they need video or do they need to have like a recording of the mouse moving around to the button, or what do they need?
I don't know that they need to have video, Your Honor, but they have to have something more than just a document that says my client signed it. Because and you have also, I think it's important to understand that this is Aerotek's solution here is in search of a problem. This is not something that happens very often. I can tell you, I've spent 26 years practicing law. I spent 17 years doing defense work for employers. And this is one of the rare occasions where it's come up where there have been multiple clients all telling me the same thing. I don't dispute, and we have never disputed, that our clients went through and performed the onboarding online. Somehow, though, the document one of the documents that they said was in front of them, my client said it wasn't in front of them. And I don't know what happened on Aerotek's end. All I know is I have not one, not two, not three. Well, three saying I went through it and it wasn't on there. And then a fourth one saying they never mentioned it to me. And that's the other thing, is that there's been this not so subtle inference that I'm the one that drove this because the affidavits have similar language. Well, of course they have similar language. The affidavits I have clients coming to me saying that this is something that we need, that we didn't see, that was not part of the transaction. I would know this. And then I'm asking them all the same questions. Are you sure you never saw this? Are you sure you never signed this? Nobody ever mentioned this. I mean, I went through a number of questions. So of course their testimony is going to be similar. And yes, I wrote the affidavits just as I'm sure Mr. Quorum drafts his client's affidavits after he gets their facts and their input. But this was not attorney driven, not at all, because I deal with these arbitration agreements quite frequently. And this is one of the first times I've ever had people come in and say, no, this was not what I signed. This was not part of the deal. And it wasn't just one, it wasn't just two. I got 3 different people telling me the same thing. I have an obligation not to have people testify untruthfully. But I also have to listen to my clients when I've got 3 clients telling me adamantly, no. And it's interesting because in this particular case, I've got one client in particular who understands what an arbitration agreement is, which is more than you can say for Sybil Harper, who's the person that gave the information to Mr. Allen. She testified she didn't remember Mr. Allen. She didn't remember anything to do with him, and she didn't even know what arbitration meant. I had one client in this case that I know what arbitration is, and I wouldn't sign it. One of the things that counsel has continued to say throughout this is that somehow this imperils all contracts. He's been making this contract Armageddon argument forever, and it's just not true. I mean, there are disputes about signed contracts. There are disputes about electronic contracts, but there's not this collapse of the economy that has followed after any of the El Paso Court of Appeals decisions. And as it pertains to the Electronic Signatures Act, the FAA itself specifically recognizes that there may be disputes about the arbitration, about whether or not there's an actual arbitration agreement. That's 9 U.S.C. Section 4. But again, there's not this tsunami of litigation. Aerotek's got a solution, a one-sided solution that's in search of a problem, and there isn't a problem. The dissents.
Mr. Scott, if the trial court had ruled the other way, would the Court of Appeals been required to reverse?
Your Honor, if the trial court had ruled the other way, I don't have any way to appeal. There's no interlocutory appeal from the grant of a motion to compel arbitration.
If you could seek review, you could seek review by mandamus.
It is my understanding. I have never done that, and I have never seen a mandamus. If there's case law out there to that effect, I am unaware of it. And no, I don't think the court, if the trial court had, and I'll give you an example, the answer is no. I've got another case where I did have a client who contested, and the trial court ruled against me. That was it. We did not seek mandamus. We didn't go forward. And no, I don't think the Court of Appeals would have been required to reverse. The trial court is the one that makes the call. And I think that's the other thing that's important is the Silva case gives you a real good example of why there's no problem with the law. Silva, though, is very distinguishable. In Silva, she alleged that she did all her onboarding in person, in paper. Yet the client, the employer, Burger King, had no handwritten documents from this individual. All of the documents, the onboarding documents, were electronic. And Ms. Silva produced no documents showing that she had done the onboarding in person. So at the end of the day, I understand why the Court of Appeals says there's just nothing here. There's no way. It is completely beyond the realm of possibility for the trial court to have found that there was no agreement. That is not this case. In this case, my clients all agreed that they completed their online, their onboarding paperwork online. They don't dispute that. They don't dispute that they went through a number of forms. What they do dispute, though, is that in this particular case, there was no arbitration.
Mr. Scott, the hypothetical that I used with your opposing counsel, where instead of electronically signed documents, it was all physical documentation and expert testimony and all of that. You mentioned earlier in your argument that those facts would be even stronger for the petitioner than the facts that the petitioner actually put on here. But it would be your position that even under those facts, the really, really strong facts that I described involving physical evidence, it would still be your position that as an appellate court, we would have to affirm the trial court's factual finding in this case?
Well, there's one thing in particular that you've mentioned in that scenario that is not, it differs from what you just said, and that is that you had people who sat there and witnessed them sign the documents. I'm not saying that there's never a situation where the trial court or the Court of Appeals can say that the evidence is legally insufficient. And if there, I don't think there needs to be a change in the law, but if there's going to be a change, then it would be to allow the courts of appeals to look at the evidence and do more than just a legal a factual sufficiency, give them a little bit more latitude to look at that, but not this blanket rule that says one side wins. Because if you're creating a rule that the corporation produces a document as presumptively valid, I don't know how I contest that. And Mr. Coram talked about asking for discovery. I can tell you that in the 2 or 3 times this has come up in other cases where I've asked for discovery, absolutely will not agree to it, will not do it. The trial courts are hesitant or just hostile to ordering it. But that would certainly be one way to go about it, other than this blanket rule that says if the corporation produces it, the corporation wins. I want to talk a little bit about the dissents. The first one is the dissent by the late Justice David Bridges, and I knew Justice Bridges for many years, but his opinion in this case was just terribly off the mark. He would have held that my client's affidavits were shams that should be disregarded. Why? He provided no explanation, none. Now, a sham affidavit requires inconsistent testimony from the same person. My clients never testified differently, and he gave no explanation as to why we should just wholesale ignore their testimony.
Mr. Scott, if there had been no evidence from your clients and the same evidence from Aerotek that we have here in terms of the execution, would you say that the Court of Appeals could still have reached the result it did by saying that the trial judge just could have disbelieved that testimony?
No, I would not say that. No, absolutely not. And honestly, if my clients would not have been willing to testify to what they testified to, I wouldn't have opposed the arbitration. I've got 2 or 3 cases that in the last month where we've agreed to arbitration. My concern here is this notion is that they've backed away from it now, but what they've asked for in their brief is basically this presumption. And the problem with that presumption is real simple. I'll give you an example. I have a case now, and it's brand new. The defendant just filed their answer, and they sent over an arbitration agreement. I haven't even, because of the storm last week, I didn't even get a chance to talk to my client. But it's an arbitration agreement, and then for the signature block, it has my client's printed signature, no date, no timestamp, and then it has an IP address. If there is this presumptive evidence that the corporation is telling the truth, the only way for us to, if my client tells me, no, I did not sign one, and that she has to tell me, no, I did not sign one, now I don't remember, that's not enough, then there has to be some way for us to test that, because otherwise you're not talking about a presumption, you're just saying one side wins. And that is just, that is a scary proposition, because it will go from arbitration to everything else. And in fact, in that case, if Aerotek had its way, you would be treating arbitration agreements better than you would be treating other contracts. That's not what the FAA or the Texas Arbitration Act requires. It says they're on equal footing. They don't want equal footing. They want it elevated. They want it to the point where if they say it, then it happens. Again, I don't think that is something that the court needs to do, but if there's going to be a change, then it is one where the court ought to give the courts of appeals a little bit more latitude. Part of my issue with the dissents from the Court of Appeals, Justice Shank spent a lot of time talking about parole evidence. I have no idea why. This case does not implicate the parole evidence rule. Parole evidence is you don't get to talk about what a contract means when we can look at the contract. Parole evidence has nothing, it says nothing about whether or not there was an actual contract to begin with. And the other part of it that bothers me is that in 2017, I believe, I'm sorry, 2017, the Dallas Court of Appeals decided a case called Constantine versus Walmart. And in that case, the individual who, John Morgan was the plaintiff. He was an employee of Walmart. He was murdered. His estate, his daughter, his last name was Constantine, filed suit against Walmart for his murder. Walmart moved to compel arbitration. Constantine argued, well, there's no evidence that he signed this. And this actually goes to, I think, one of the hypotheticals you gave, either Justice Busby or Justice Boyd, where the Constantine wasn't able to put on any evidence to refute it. And in looking at that case, the Dallas Court of Appeals said, and it went to the Kmart versus Ramirez case, it quoted Ramirez and said, in Ramirez, the employee's denial of receipt or signing the arbitration agreement was sufficient to create a fact question for the trial court to resolve. There is no such evidence here, therefore we're going to order and compel arbitration, and that was the right result. But they cited to Ramirez, they cited it approvingly. Nobody had any issues with the court citation to that, and none of the justices who dissented in this case from the denial of en banc appeal dissented from the denial of en banc in Constantine. The only thing that's different there was the result. They didn't like the result in this case, so they dissented. They didn't have a problem with the law in Constantine because the result was we're going to compel arbitration. I don't think, that is result-oriented judging, and I don't think that's proper. And I do think that's what some of the dissents did in this case. Again, I'm almost out of time. I will say, if the court is going to change the law, I do think it is fair that we be given the opportunity to go back to either the Court of Appeals and or the trial court. We followed the law that was in existence at the time. The trial court followed the law that was in existence at the time, and so did the Court of Appeals. We respectfully request that the court affirm the Court of Appeals judgment in all respects. Thank you.
Any other questions? Thank you, Mr. Scott. Mr. Corum, I believe you have 5 minutes.
All right. Can you hear me?
Yes.
Perfect. Thanks. First thing I think I need to make a point of, since there is a record of this, obviously, is while it is true that I was in from Kansas City for the TIPS hearing, everything else Mr. Scott said about that was false. The affidavits were not provided because I didn't want to wait. I travel every week until COVID, at least, and I never allow my schedule to interfere with what I'm doing for a client or in a courtroom. So that's just not true. I didn't choose the affidavits, and it certainly wasn't because I didn't want to stay. He claims that we're seeking a presumption of truth, that the corporations, if they merely say it, it happened, and that's what we're asking this court to apply as the law in Texas. That's just never been the case. We've never argued that. You cannot find that argument in any brief we filed at any level, and we're not arguing that today. We seek to apply this court's standards set forth in Keller, that we conclusively established the facts that were relevant to the issues before the trial court. The question I'd ask you guys to consider is, what more could we have done? That question was asked of Mr. Scott, and his answer was he doesn't know. He says he's not
Could you have provided documentation to the other party, to the counterparty at the time signatures were affixed electronically, or do you provide that documentation? Is it available for download, that kind of thing, to avoid the later determination that someone didn't sign?
Yeah, Justice Bland, absolutely, that's made available, and there was evidence of that as well. Every individual applicant, all 465,000 of them in 2017, are provided an opportunity to not only read and execute those documents, but to download and get copies of those documents. So absolutely they do. He indicated
copies indicating execution of those documents as opposed to just the form.
Well, the very first document that they execute when they go to the website and after they create their password, as the evidence was at the TIPS hearing, is an acknowledgement and an agreement that they're going to execute the rest of the documents electronically. That acknowledgement is the first thing that they have to execute. And they get not only that with their signature, but all of the other documents with their signatures as well. Now, not everyone chooses to get those documents, as you might imagine, but they're certainly made available to those individuals. He suggested, Mr. Scott, that is, that we might have brought an IT person, and the court talked about that as well. I will suggest this. Based on what the Fifth Court of Appeals said, it wouldn't have made any difference. I could have brought in every IT person in the country. I could have conducted a survey of Mr. Scott and his client and brought in every witness that they suggested and presented them for 2 weeks. And according to the Fifth Court of Appeals, the trial court might just disbelieve them. That's the standard. Well, if you look at what
the quorum, it just what's difficult about this case to me, I mean, you're a seasoned litigator. I tried a lot of cases, and sometimes the juries just get it wrong. They just do. And it's frustrating, and it's certainly frustrating to the lawyer, but even more so to the client. But here, of course, it's the judge, not the jury, who's the fact finder. But why is this case any different than a case where the fact finder just got it wrong?
Well, it's different because it depends on the quantity of evidence. That's the Keller standard. That's the conclusively established issue. That's why the court in Fries, after the employer there, Justice Boyd, provided evidence of their onboarding system and the processes they went through, and the employee, just like our case, denied having received or executed the document. The court said, based on the evidence presented from Fries at the evidentiary hearing, the trial court could have drawn only one reasonable conclusion. The employee completed the online job application found in her personnel file, and she consented to the arbitration agreement with her digital signature.
It's really, under Keller, it's not a question of the quantity of the evidence. It's a question of the existence of any controverting evidence. For us on appeal to say that the trial court, as the fact finder, just got it wrong, we have to find that there's just simply no evidence in the record, not more than a mere scintilla, that contradicts your evidence. Isn't that true?
Yeah. And in the Fries case, the 13th Court of Appeals said there was no more than a mere scintilla. And even though the employee denied having received or executed the electronic agreement, in light of the quantity and quality, I guess you should perhaps consider both, of the rest of the volume of evidence that had been presented by the employer. So when you look at all the evidence, sure, fact finders can get it wrong. Trial courts and juries can get it wrong. But the question is, could this fact finder have reached any other reasonable conclusion in light of the evidence that was presented? And if the answer is no, then the decision can be reversed on appeal. And there is a framework provided by Keller to do that. We'd ask that the court reverse the decisions below, consistent with the arguments we've made, the briefs, and the dissents of Justice Schenck, Bridges, Myers, and Evans. And unless there's other questions, I'm out of time, Your Honor.
Any other questions? Thank you, Mr. Coram. The case is submitted, and the court will take another brief recess.